Nothing contained in this videocast is intended to encourage the use of illegal substances. This videocast represents only the opinions of the host and their guests and should not be taken as medical or legal advice. In no way does listening, reading, corresponding, or interacting on social media with our content establish a doctor-patient or legal relationship. The content here is intended to share thoughts and opinions and foster constructive discussion. Please consult your healthcare professional for any medical questions concerning cannabis. The views expressed by hosts and guests on this videocast are not necessarily the views of Global Cannabis Times or any other company with which the hosts and guests are associated.
Welcome everyone to an episode of Going Global, a Global Cannabis Times podcast with myself, Carla Pareja and Julio Sanchez. And today we will be discussing the very exciting topic of the developments of the legalization of cannabis in Mexico. I'm going to start by introducing myself, and then I'll pass the mic to Julio so he can do the same. I am an associate at Zuber Lawler, a law firm with offices in 7 cities across the United States, who has been representing cannabis medicine companies in deals and disputes for over 16 years. We are a full-service boutique firm, and I myself specialize in cross-border transactions with a particular focus in Latin America and Spain. Julio, tell us a little bit about you.
Thank you very much, Carla, and welcome to this podcast. Very important for Mexico. Regarding the opportunities that our country, Mexico, has in the industry of cannabis. Let me talk very quickly about my experience, my background. I'm a lawyer. I also studied economy and have several studies regarding regulation specifically. My background, I worked for basically 20 years in the federal government in different authorities. Regarding economic competition. Also, the last 8 years I worked at the Federal Competition Against Sanitary Risks, which is basically the Mexican FDA. It is called COFEPRIS. And in that time, I had the opportunity to report to the Ministry of Health and work specifically in the issuance of the first legalization, the first law that legalized cannabis, that was in 2017. So basically, I had the opportunity to draft the first law in cannabis for Mexico, and I've been following that since then. Now I am partner of a law firm, which is called Health Sanitary Consulting. We are a business strategy firm that represents many companies across Latin America. We are specialized in regulatory affairs and also in compliance processes. We are working at this moment in different areas regarding the cannabis industry, and I'm very glad to be participating in this podcast with you, Carla, and all the team.
Great. And I don't want to forget, let everyone know that Julio and I will be attending and speaking at the Canamexico World Summit on October 19th and 20th, 2022. And the Canamexico World Summit will be hosted by the 55th President of Mexico, Vicente Fox. And Canamexico is an international business-to-government and business-to-business networking multi-platform that allows analyzation of the 5 big transformative forces that are defining the evolution and the changes of the national and international cannabis markets. So all the key players of the Latin American cannabis industry will be present. We encourage everyone to join us at this event. You can visit the website www.cana-mexico.com. And it's going to be a great event. So we hope to see everyone there. Now, let's get started, Julio. We are going to start this panel by giving everyone a little bit of an introduction on how the cannabis in Mexico, the legal cannabis in Mexico has been developing and what the milestones have been to get to where we are today. And after that, we're going to be talking about what can and cannot be done today in relation to cannabis in Mexico. So everything started, Julio, in August 2009 when Mexico decriminalized the possession of small amounts of cannabis. And that was in order to reduce the illicit drug activity. And that was during the presidency of Felipe Calderón, who claimed that the change would allow law enforcement to focus on major traffickers rather than minor consumers. So I think that was the first kind of milestone, the first important development of cannabis in Mexico, until November 2015, in which the Supreme Court made its first ruling to allow the growing of marijuana for personal use. And that allowed a particular group of 4 individuals from the Sociedad Mexicana de Autoconsumo Responsable y Tolerante, and it allowed them to grow and consume their own cannabis. And I think, Julio, that ruling basically opened the door to legalizing marijuana in Mexico.
Sure. Thank you very much, Carla, for that introduction. Basically, the history in Mexico regarding cannabis can be told very quickly regarding the era of prohibition. Since 1936, there was a decree that prohibited cannabis in all the forms, in all the uses, until 2017, when the General Health Law was issued. This modification of the General Health Law was supported by a previous movement, let's say a social movement that took place in Mexico, and where some of the conclusions of this social movement that started as a social movement, but then was converted into a political movement as well. The conclusions of that period that started since 2015 was first that the cannabis as a plant should be viewed as a plant that has many and different uses. It can be used for medicinal purposes. It can be used for industrial purposes. It can be used also for recreational purposes. So basically, the law that was issued in June 2017 contains only two of those three uses. It doesn't regulate recreational use. Actually, it is decriminalized, let's say, in little amounts, but it doesn't say, the law itself doesn't say that people can use cannabis for recreational purposes. That is a different story that we are going to explain you a little bit. But that law in 2017 specified that cannabis can be used for medicinal purposes and for industrial purposes. So basically, we have a general health law since 2017 that allows people, companies, individuals to use cannabis for those specific purposes. But regarding specifically the medicinal use of cannabis, it was not regulated into a secondary regulation, into specific guidelines that could give transparency to the industry until January last year, January 2021. So even though the law was issued in 2017, there was no secondary regulation. There was no specific rules or criteria to basically develop a dossier, a pharmaceutical dossier, and present that dossier to the Mexican authority, COFEPRIS. So that was issued in 2021 in January, and that gives a big opportunity for the industry that wants the national industry and the foreign industry to go to COFEPRIS to present a formal dossier, a pharmaceutical dossier, considering all the regulation that already exists for the pharmaceutical industry, and require a permit, which is called specifically a registration, a market authorization for a medicine containing cannabis. So the basic rule is that medications, drugs containing cannabis can contain not only THC, they can contain other cannabinoids, CBD, CBG, CBN. There is no restriction for that. And also the regulation, the specific regulation for medicinal use from last year does not specify the concentration of THC or CBD or CBG. It doesn't say anything about that. Everything is related in that regulation or focused on demonstrating efficacy, quality of the medicinal products in order to receive a market authorization.
Yes, exactly. So like Julio mentioned, in June 2017, what happened is that the bill, the President Enrique Peña Nieto signed a bill into law. And it allowed the medical use of cannabis products containing less than 1% THC, but it didn't have a set of regulations. So the law, basically, the bill that was signed into law authorized the Ministry of Health to enact these new regulations, which were enacted in 2021. But it was great to see Mexico joining many other countries in changing its law to finally allow access to those in need, because medicines is a fundamental element of the right to health. And it was great to see Mexico following up on other countries who already set precedent on this regard. So as Julio mentioned, the regulation, the Mexico's health ministry published rules to regulate the use of medical cannabis in January 2021, and that's the Reglamento de la Ley General de Salud en materia de control sanitario. So going back again, in October 2018, there was another milestone, but that milestone was with regard to recreational cannabis, not medical cannabis. And that's when the Supreme Court ruled that an absolute ban on recreational use of marijuana was unconstitutional. And it effectively left it to the lawmakers to regulate the consumption of the drug. And that was the fifth time that the court had ruled in this way. And Julio, tell us why the 5 is the magic number with regard to the Mexican legal system, and why the fact that the Supreme Court ruled the same way 5 times made a huge difference.
Sure. According to the Mexican legislation, if an individual or a company presents a constitutional trial to the judges, to the federal judges, and that trial goes to the Supreme Court, there should be 5 different trials in the same with the same, let's say, legal substance, and there should be chronologically, let's say, presented, so that no other criteria in these 5 trials is contradicting the criteria that is established in those trials. So basically, if there are 5 trials in the same sense, in result with the same criteria, these criteria can be converted into a jurisprudence. And that is what happened in 2018. Since the first trials that were presented to the federal judges in 2015, then we have no 5, but we have 8 trials in the same sense. So basically, the Supreme Court issued a jurisprudence that basically is a criteria that is mandatory to the federal judges, regarding what you already explained, Carla, that the general ban or the general prohibition of cannabis, and that is what the jurisprudence says, is not an essential element to protect public health. So this is very important, because actually the Supreme Court is saying, hey, if you want to protect public health, it is not a necessary measure to ban or to set a prohibition for cannabis. So from that jurisprudence, from that general declaration, that is the concept, Declaración General, general declaration of inconstitutionality. What is unconstitutional? The prohibition. So with this general declaration of the Supreme Court, any individual, any company can present, is allowed to present to COFEPRIS a specific application to grow the plant in Mexico, to consume the plant in Mexico for recreational purposes. There are some restrictions. The first restriction is that you cannot commercialize it. You can grow it. Actually, you can import the seeds. You can grow it in Mexico. You can basically have it in your backyard with that amparo, with that permit issued by COFEPRIS, supported by the Supreme Court decision, but you cannot commercialize it. And the second restriction is that you cannot basically use the cannabis for recreational or individual purposes in front of third parties. So basically, there is a very let's say a clear way or clear path, legal way to produce cannabis in Mexico for recreational purposes. But as I said before, this is not established in the General Health Law from 2017. The way in which the Supreme Court decided this general declaration is because some trials were presented since 2015. They created jurisprudence, and now the Supreme Court not only decided that it's unconstitutional, but also that the Congress should develop a new legislation for cannabis that is actually at this moment being discussed in the Senate, and that general law a new law about cannabis should establish not only the possibility to use the cannabis for recreational purposes, but also to commercialize it, not only for individual purposes with this restriction to not commercialize it, but generally to grow it and to commercialize it in Mexico. So that is why this decision from the Supreme Court that was issued basically last year in September, it is so important because it gives the opportunity in the following, let's say, months or maybe years. We don't know how the Congress is going to approve this law. I mean, regarding the period of time, but it is already in discussion, and the Supreme Court gave a specific mandate to the Congress to develop that law.
Exactly. So basically, the effect of the declaration of unconstitutionality of the Supreme Court in October 2018, the basic effect was that prohibiting cannabis still remained in effect, but it should no longer be enforced due to the fact that anyone could cite the ruling and demand that their charges be thrown out. And the ruling mandated the government of Mexico, as Julio mentioned, to move formally to legalize cannabis within 90 days. But there were a couple of extensions. And as Julio mentioned, today the process is still pending. In March 2021, the lower house of the Mexican Congress approved a bill to legalize recreational marijuana, el proyecto de decreto. Again, as Julio mentioned, it still needs approval of the Senate. Presidente Andrés Manuel López Obrador already signaled support for the legalization. But the legalization was not completed before the end of the legislative session, and the legislature did not ask for an extension. So that's when the Supreme Court listed the declaration of unconstitutionality on their docket for a vote on June 28. So Julio, tell us a little bit more about what this declaration of unconstitutionality means in the Mexican legal system.
Sure. Well, when the jurisprudence was generated, the Supreme Court initiated a process that is called, according to the Mexican Constitution, it is called the General Declaration of Unconstitutionality, which broadly establishes that the Congress of the Union, the legislative power in Mexico, has, as you said before, 90 days to make the corresponding modifications to the law, in which the absolute no to the prohibition of the consumption of cannabis must be established. And in this declaration, it also says that COFEPRIS must grant the corresponding permits for personal use of cannabis, and the use of cannabis must not be solely for medical and scientific purposes. That is the importance of this declaration. At this moment, neither the Congress or COFEPRIS have complied with that declaration. Although legislation has been passed on the matter, no consensus has been reached for the publication of the modifications to this law. But we know that the Congress is discussing at this moment this new legislation. We expect that with the issuance of the individual permits from COFEPRIS to individual persons, to use it for recreational purposes, there is a important pressure from the market itself, from the individuals that are growing in their homes cannabis. So this is, I believe, an important element or factor, a critical factor that pushes a little bit the Congress to resolve, to regulate the recreational use of cannabis, because it is already here.
Right. And although the body no longer has the deadline to meet like it happened before, because the declaration of unconstitutionality already took place, there are growing calls from society to regulate the market beyond homegrown. And there are also a lot of legal contradictions today in the Mexican legal system that need to be harmonized, right? Because you have, although you have state and federal penal laws that remain in place, there is pending action by the Mexican Congress to clean up all these inconsistencies and remove the penal language. And for those U.S. Listeners that we have, unlike in the United States, Supreme Court rulings in Mexico do not automatically invalidate all existing laws. So that works differently than how it works in the United States. But I think we are in a very exciting moment in Mexico. We are hoping that things develop positively in short order. And with more than 120 million people, Mexico would represent the largest marijuana market in the world by population. It's a huge market. And I think that by becoming the third country in the world to regulate adult cannabis use after Uruguay and Canada, Mexico could transition from being one of the largest illegal producers to being the largest legal domestic market in the world. So it's definitely a very exciting time for Mexico. We hope that we can see the legalization, formal regulation of recreational cannabis in Mexico soon, and companies can continue carrying out their activities and the cannabis business in Mexico booms. Now that we went a little bit through all the milestones, the chronology of how the Mexican cannabis legal system developed, let's focus a little bit on where we are today, Julio. And I think for the listeners to understand how we're going to organize things, I think we can separate it with the medicinal world, the recreational world, and the industrial world. So today in Mexico, in relation to medical cannabis, what can be done and what cannot be done?
Let me be very straightforward. There is a very strong regulation at this moment for the medicinal use of cannabis. There are different, let's say, rulings that are valid today that support the opportunity to bring to Mexico medical products with cannabis. The first one is the general law, the general health law from 2017. The second one is the specific regulation for medicinal use that was issued January last year. And the third one that is also very important is that the products with cannabis have, according to the current sanitary regulation, they have a very specific classification. And this is important because when the Ministry of Health decided that cannabis can be contained in medicinal products, then the regulation that is applicable for drugs, for medicinal products, can be also applied to cannabis. So at this moment, every single product that can be developed with cannabis, the classification of these products are in what we call controlled medicines. What does this mean? It means that they are considered as psychotropics, that they have a classification according to the specific ruling for medicines, under the classification of, let's say, fraction 1, 2, and 3 of Article 290 of the Mexican legislation. That means that every person that can be developing a medicinal product abroad or in Mexico have a specific classification, a very strong regulation to present an application, and basically COFEPRIS is obliged to review the application, to apply the let's say the regulations regarding quality and efficacy, and is obliged as well to respond to the applicant. What can COFEPRIS respond? For example, they can respond that there is some information missing, that there is some elements or studies that could be also missing. But the thing is that they are obliged to follow the process, to follow the formal process according to the current regulation for medicinal products.
So what about with regard to recreational cannabis, Julio? What can and cannot be done today?
Okay. The recreational personal use of cannabis is fully authorized in Mexico, but not because of the health law that was issued in 2017. If you look for recreational purposes in that law, it is not going to be there. Mm-hmm. It's basically ruled according to these rulings that we explained that issued the Supreme Court of Justice of the Nation of Mexico, that is the Supreme Court in Mexico. These rulings derive from lawsuits filed against COFEPRIS refusals to grant recreational use permits to individuals or associations. The first ruling, as we explained before, occurred in 2015, in which the court decided or declared the absolute prohibition of personal use of marijuana as unconstitutional. Then many other lawsuits were presented, and in 2018, the court granted 3 amparos. That is the name of the lawsuit in Mexico. It is a constitutional trial. It's basically a judicial remedy for the protection of constitutional rights. Mm-hmm. And the court granted, as I said, in 2018, 3 amparos for personal use of marijuana and allowed importation or acquisition of marijuana seeds. Likewise, in 2018, 2 more amparos were resolved in which the court reiterated the unconstitutionality of the absolute prohibition of the recreational consumption of marijuana. And since it is the 5th time that the court has reiterated this precept, this criteria, the jurisprudence, the magic number, the 5 magic number, exactly. So when the jurisprudence was generated, the court initiated, as I explained before, this process that is called the General Declaration of Unconstitutionality. So it is very important how the ruling of the recreational purposes of cannabis is not derived from a let's say administrative power from the president and the Ministry of Health. It is derived from a decision that has its support on constitutional rights. Right. So that is why the General Declaration is so important, because in the center of the legal discussion is the right of an individual to decide what to use, what can the individual can consume, even though cannabis has some health preoccupations. But that is not in the center of the discussion. As I said before, the name of this jurisprudence is, it is basically explaining that the legal prohibition, that the general prohibition is not a necessary measure to protect public health.
And is it true that if one wants to obtain a permit for out for the consumption of marijuana, of recreational marijuana, basically you have to apply for a permit with COFEPRIS, wait for COFEPRIS to deny the permit, and then go to the court so you can obtain the legal support for you to obtain this permit. So it's basically, you know what's going to happen, but you have to go through the application, the denial, and go into the court to get to where you want to get, right? Because the COFEPRIS is not issuing permits upon application from users. Is that how it works?
Well, there are two moments. Before the general declaration of last year, many applicants presented to COFEPRIS these applications to the personal use of cannabis, and then COFEPRIS didn't respond. Then these persons went to the judges, and then that is how these many trials were developed and basically reached the Supreme Court that generated the general declaration. But for the first lawsuits that started in 2015, the judges didn't wait until the general declaration. So right. So in individual trials, the judges gave the order to COFEPRIS to issue the individual permit. So at this moment, I would say there are at least 8 individual permits to persons that are basically growing the plant in Mexico.
Right.
So that was before the general declaration. And then after the general declaration, many other persons, as you can imagine, presented their own applications to COFEPRIS, because COFEPRIS is obliged by the general declaration to issue the permits. At this moment, from the general declaration, COFEPRIS has not responded, but is obliged to do it.
That's what's surprising. Even though there is a general declaration, COFEPRIS is still not responding, and that's probably because there isn't an actual body of law regulating and for COFEPRIS to follow a specific procedure. So they still don't respond. And although applicants don't have to go through the whole Supreme Court process, they still have to go to court to obtain their permits.
Yes, but with a different argument. It's not the same thing to go and say to the judges, hey, COFEPRIS is not responding me because I want right. to use cannabis for individual purposes, right. than hey, COFEPRIS is not responding, even though the Supreme Court is obliging the authority to respond. So it's a different, yeah, exactly. It's a different process because actually, if COFEPRIS do not respond to the applicants that are presenting their applications with the support of the general declaration, if COFEPRIS do not respond, then the officials of COFEPRIS and the general director of the commissioner, the federal commissioner, can be sanctioned right. by the Supreme Court, by the judges. And the sanctions are really important, and they can be economic sanctions, and they can actually, let's say, ban the opportunity of those officials to keep on working on the federal government. Mm-hmm. So there are important sanctions to the officials and to the authority itself if they do not respond to these applications.
Great. Okay, I think we gave a good idea on where we are now from a recreational perspective. Why don't we explain a little bit where we are from an industrial cannabis perspective, which is also a separate world from the medical and the recreational cannabis?
For sure. Actually, in 2017, Carla and team, there is one article that is the article 245 that specifies that cannabis can be used for general industrial purposes. That is the concept, general industrial purposes. There are 2 restrictions, not restrictions, but 2 elements that are present in that article. The first one is that for industrial purposes, cannabis cannot be, should not have more than 1% of THC. Okay, so that is the first element, or the first factor. The second one is that the cannabis, whatever the pharmaceutical form it is, it can be an extract, or it can be like a liquid, etc. It should comply with the current sanitary regulation. So if you analyze that article, basically you can conclude that yes, cannabis can be used for industrial purposes if the product does not contain more than 1% of THC, but you should present an application to COFEPRIS because you should comply with the current sanitary regulation. And the authority that can basically say if you are compliant or not is COFEPRIS. Okay, so even though the industrial purpose for cannabis is established specifically in this general health law in 2017, there are no specific permits issued by COFEPRIS to the applicants for industrial purposes. So happened the same thing. I know many companies that actually presented applications for industrial purposes that basically are cosmetics, food, dietary supplements, or even raw material that can be used for textiles, etc. So they presented applications. They actually developed very technical dossiers to demonstrate to the authority that, for example, the cannabis is contained in a dietary supplement, that it does not contain THC, it contains CBD, it is not psychotropic, it is the labeling is according to the current regulation. Everything regarding the product around the production, labeling, advertising, everything is correct according to regulation, but COFEPRIS is not responding. So these first applications were presented basically after the 2017, June 2017, when the law was issued.
Yep.
But at this moment, COFEPRIS has not responded, and basically these companies have went also with lawsuits against COFEPRIS because of the omission to respond to those applications, and they went to different trials in different levels, first to an administrative trial, and then actually went to the Supreme Court as well. And at this moment, the Supreme Court has also already issued not 5, but yes, two criteria. We are very near to this magic number. Yeah, we're getting there. But the Supreme Court has issued a very important criteria regarding the industrial use of cannabis, very similar to what happened for the recreational purposes, but right now for industrial purposes. And now with these 2 cases, the companies that have received that protection from the Supreme Court have started commercializing products with cannabis in Mexico legally. And again, not because COFEPRIS has granted the permits or has responded that the product complies with the regulation, but because the Supreme Court ordered COFEPRIS to basically to grant those authorizations.
And now it's particular to these 2 companies, but or any other company that brings the process to the Supreme Court. But hopefully, by the time there are 5 rulings, we can get to the similar position that we were with the recreational cannabis.
Oh yes, this is a very important question. In the legal system of Mexico, when you present a trial, a lawsuit, an amparo, a constitutional lawsuit, the effects of that amparo are only related to the applicant. They cannot be generalized. So that happened in the recreational study. To remember that we said the first 5 amparos were granted to individual companies, and they have the right to use for recreational purposes. And then with these 5, the Supreme Court has started the process of general declaration of unconstitutionality. So an individual amparo protects an individual, but the general declaration of unconstitutionality protects the general, let's say, environment, the public in general. So that is what we expect that is going to happen with the industrial purposes, let's say, arena. We are following these amparos. There are some important criteria regarding the legal use of cannabis for industrial purposes. And at this moment, as I said before, 2 companies have received this protection from the court to start commercializing products in Mexico. But that is going to happen in some months, in some time. Many other companies have presented the same applications. They are going to reach the Supreme Court decision, and the Supreme Court is going to say, hey, I already said that for recreational purposes, it's unconstitutional to prohibit that. How it is possible that COFEPRIS is not responding regarding the industrial purpose of cannabis when the products for industrial purposes are not even psychotropic? Right. You know? So it doesn't make any sense. So we are expecting in the following months, hopefully, to have a general declaration, hopefully for industrial purposes of cannabis in Mexico.
Yeah, it doesn't make any sense, but that's how the legal system is in Mexico. And basically, we have to go through the whole process to get to where we want to get. And it's going to take some time. And it takes time for judicial proceeding in Mexico to reach all the way to the Supreme Court. But we're going to be patient, and hopefully soon we get to that point. Now, Julio, what about imports and exports? Because I know a lot of, at least a lot of my clients are very interested in being able to export products to Mexico. Obviously, in the United States, due to the interstate commerce, cannabis cannot be exported, even though it could be imported into Mexico, which is not the case. But what about hemp, for example? Can I tell my clients, my clients in the United States, that they can export hemp into Mexico?
Yes, but with some important restrictions. The production of raw material with cannabis, I mean flower, is allowed and is regulated at this moment in the regulation regarding the medicinal use. It is established expressly that any company, any individual can actually grow plant in Mexico, but only for health-related purposes, only to use it for the production of medicinal products. Right. So it is let's say, it is complicated to understand how this works, because one, if you can basically create or grow the plant in Mexican soil, you can basically import the seed, grow it here, transform it into a pharmaceutical product. But the thing is that you cannot commercialize it. Why? Because it can only be sold to the producers of cannabis products. And at this moment, no one has presented or been or has authorized a medicinal product to commercialize it in Mexico. So if someone wants to come to Mexico and grow plant here, they can do it, but they will not find a current market until a medicinal product is produced and authorized. Right. Or the company can come to Mexico, grow plant in Mexico, and also be integrated into a pharmaceutical company that can basically develop the medicinal product and integrate this chain where the same company grows the plant and they sell it to the producer of the pharmaceutical product. So yes, at this moment, you can grow the plant in Mexico, you can import raw material, actually you can export raw material as well. It is established in the regulation, in the medicinal regulation from last year. But the thing is that there's some let's say chains that are not good, well understood. So at this moment, pharmaceutical drugs are allowed, are very good regulated, and basically there's a great opportunity to import a raw material, to transform it, to manufacture medicinal products, and to export them to any country in the world. But the thing is that in order to do that, you need first to be granted with the permit to import the plant, to transform it, and also in somehow be integrated to the manufacturer that actually can transform the cannabis and present it to the authorization, to the market authorization as a final product to COFEPRIS. The cannabis market is growing, growing very rapidly. I would say that we have strong regulation regarding medicinal use of cannabis. We are working and many things are happening at this moment at the Senate with a new law. Also, the judges are really aware of this general declaration of the unconstitutionality of the prohibition of the cannabis. And now the industrial chambers in the pharmaceutical sector, in the food sector, in the dietary supplements sector are really aware that this is happening, are waiting for the new criteria from the court regarding industrial purposes, and are participating actually in Mexico, many of them, but these are not individuals that want to use cannabis for individual purposes. These are big companies, big, let's say, organizations that are really professional in terms of their production, in terms of their processes and capabilities to expand the cannabis industry in Mexico. So this is the moment when we should look at the plant, at the opportunity of the cannabis industry as an important, let's say, area in Mexico where many industrials are participating, and also with the opportunity of being one of the most important markets in the world. Mexico is a big country. We have many land. We have very professionalized industries. So I believe this is a critical moment for the cannabis in Mexico.
Yep, I agree. Great. Well, very exciting times in the Mexican cannabis market are coming, and we'll certainly be following the developments very closely. If anyone wants to know more or needs any assistance in relation to Mexican cannabis, you can feel free to contact Julio or me. Our contact information is going to be on the link under the video. We are running out of time, so although the conversation is very exciting, we're going to have to leave it here. As we mentioned earlier, if you want to know more, if you want to hear more about this topic, please join us at the Mexico World Summit, October 19th and 20th. Julio and I will be speakers in a panel. We'll be around during the whole trade show, so we'd love to meet all of you in person. And if you want to buy tickets, we're also going to leave the link for the tickets under this video. Julio, thank you very much for your time. This was a great discussion. I enjoyed it very much, and I can't wait to continue discussing in Mexico.
Thank you very much. Bye-bye.
Bye.
See you in Mexico.
Mm-hmm.